Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Thank you for coming today. We have 3 cases to argue, and we will start with our first case, Jerrycare Pharmaceuticals versus Stratus Healthcare. Ms. Giroux, is that right? Whenever you're ready.
Good morning. May it please the court. My name is Danielle Giroux, and I represent Jerrycare Pharmaceuticals Corporation. The district court in this products liability action erred in granting summary judgment in favor of Stratus Healthcare on its implied indemnification claim against Jerrycare. This is not your typical scenario where a downstream seller or distributor that did nothing but move the product in the chain of distribution then seeks to shift the liability to an upstream manufacturer. The facts here are very different. Here, both Stratus and Jerrycare took affirmative, active steps and very similar steps in that chain of distribution that led to the claimed damages of Carolink in this case. Both parties did not test the product. Both parties relied on a representation made by someone else that it was sterile. And in the case of Stratus, they also made an express warranty to Carolink, which was the party that ended up being damaged in this case. The district court should have found that Stratus's actions were active and therefore precluded its implied indemnification claim, or if there were disputed facts, it should have allowed the jury to decide whether Stratus's actions were in fact passive or active. It did not. The doctrine of implied indemnity is reserved for those individuals who are being held liable for the fault of another.
Counsel, can I just ask you a quick threshold question?
Yes.
You're talking about Maryland law, right?
I am, yes.
And everybody agrees that Maryland law applies here?
It does.
Okay.
There was significant discussion below in the district court regarding the applicable law, and we did not challenge that on appeal. Yes, we are talking about. I wish.
Could I follow up on? Yeah,
yes.
Just on one short question
Yes.
on that. Does Maryland law embrace the restatement second?
Your Honor, I believe it does, and I believe that the district court relied on that as well.
You don't challenge that either?
I do not.
Okay.
The doctrine of implied indemnification would not apply to this situation, to Stratus, who is not merely a conduit of the eyewash in the chain of distribution. There are facts in the record that support Stratus's active negligence in this case.
Counsel, how much weight, in considering this, how much weight do you think it is appropriate to give the allegations in the complaint as opposed to the factual record?
I don't think that it's error to look at the facts in the complaint, but the court needed to, in deciding summary judgment, resolve all factual inferences in favor of the non-moving party, which it didn't.
But so you think you can look at both, the allegations in the complaint, but also the factual record?
Yes, I do, and in determining what facts exist to support either passive or active negligence. In this case, we argued that the district court relied on the complaint, the allegations of the complaint, but ignored these other facts.
But then the district court came back, I thought, and actually agreed with you. I'm supposed to look at everything and did look at the facts.
Yes,
okay.
but still didn't look at the way I interpret what the district court did here is said 2 things. One is that it says Jerrycare is the manufacturer here, and because Jerrycare is the manufacturer, it was actively negligent, and Stratus, who was in the chain of distribution, was passively negligent, but didn't look at the other facts in this case that Jerrycare argued that supported Stratus's active negligence in this case. The fact that it held itself out to be an expert in the field of iBanking, and it told Carolink through its representations that they were an ideal partner for implementing medical standards to your iBank operations, and our custom trays are designed to help recover the highest quality tissue in the most efficient way.
Okay, now the court, in its opinion, ruling on Jerry Care's motion to reconsider on the indemnity, said at page 5 of its decision, any claim that Stratus should also be considered a manufacturer is insufficiently supported by the record to allow a jury to conclude that Stratus was also subject to a duty to inspect.
That's correct.
Are you claiming that they had a duty to inspect?
If Jerry Care has a duty to inspect, then Stratus had a duty to inspect. My argument is that there is no way to distinguish factually from what Jerry Care failed to do with regard to inspection and what Stratus failed to do with regard to inspection.
But don't you have a,
Yeah.
no, go ahead. I thought that manufacturers have a different duty to inspect.
So Jerry Care is not a manufacturer
But
of the eyewash. I understand for purposes of the sealed container defense that the court found that Jerry Care was an apparent manufacturer. But that statute, the definition of manufacturer for sealed container defense is much broader than just a manufacturer of the product itself.
Well,
There's no-
Jerry Care held itself out as the manufacturer,
It
did
did
it not?
it did hold itself out to be the manufacturer of the product. It did put on its label that it was a product of Korea. The problem was that to the public, they wouldn't know that Jerry Care wasn't in Korea and that it was a South Korean manufacturer that actually manufactured the eyewash, and that there was a California company that manufactured the eyewash. Jerry Care did not physically manufacture the eyewash.
No.
It worked with the manufacturers in order to develop this product for which it put its own private label on. How is that any different than what Stratus did in this case, where they took the eyewash, they put it in their own surgical packs under their name, as a distributor and manufacturer, which it held itself out to be, and put a insert inside of this product that said.
I'm sorry, Stratus held itself out to be a manufacturer?
Yeah, a manufacturer of the Strati packs.
The
So
Strati packs,
there was
got it.
an insert within the Strati packs that said that they were the distributor and manufacturer. And that insert also included the phrase that it was sterile eyewash. At no point did Stratus inspect the eyewash or test the eyewash before it made that separate express representation to CareLink in this case. So this isn't a situation where Stratus simply took the same product and then moved it from one place to another.
Well, it kind of is. Isn't your argument, if you play it out, that with respect to the eyewash, that, y'all are in the same boat? But someone upstream in Korea actually was the actual manufacturer.
That's right.
And then through a series of purchases and sales through the distribution stream, it ultimately gets to the end user. I forget who it was, CareLink, I think. But if that's what it is, aren't you liable as a distributor from an upstream distributor?
I'm not sure I'm following. Am I liable, is Jerry Care liable to?
Stratus can go back, if both Jerry Care and Stratus obtained the eyewash that was contaminated and passed it on and didn't inspect, and as you say, they're in the same boat, doesn't the restatement of torts permit an upstream distributor to seek indemnity from a downstream distributor? Just like you could go downstream to the people you bought it from. Now, I realize that's not the district court's reasoning, but it seems like under your view of the facts, you run smack into that. And, the district court actually did this under a strict liability theory, not a negligence theory, which seems like it's even a better vehicle to go that way. So I get your consternation about maybe there was some negligence there, maybe some negligence there. Perhaps the active-passive thing may not be a perfect fit. But it seems like your argument leads to, maybe a remand, maybe a reconsideration, or maybe us just deciding that this is a classic, two distributors, and you lose on that ground.
The doctrine that I'm asking this court to consider is that it should not be a rule simply in where your placement is in the chain of distribution, no matter.
That's exactly what the restatement of torts
But
says.
There
I
needs
mean,
to, if it's true that the court has to consider passive versus active negligence, then it needs to be more than just where your placement is in the chain of distribution. You have to look at the actions, the relationship of each party to the party that was injured, and the nature of their legal duty. And in this case, it wasn't just simply someone passing the product down the line. It's that Stratus took that
well,
step.
imagine this wasn't this case. Imagine it was a absolute classic, situation where there's no allegations that your client did any, held itself out as a manufacturer. You just got it, passed it on. Stratus did the same thing. Same result here. It's contaminated. There's a verdict in favor, or a judgment in favor of CareLink, and Stratus seeks indemnity from a downstream distributor. Do they get it?
They do not.
You don't think that restatement of torts that Maryland has adopted allows that?
There needs to be more than just looking at the placement in line. There needs to be a consideration of the relationship of the parties and the steps that each party took to determine whether it was passive or active in this case. There could be two parties within that chain of distribution that were actively negligent, and I believe that is the case here. There could be an argument that Stratus was even more negligent than Jerry Care, simply because of the representations that he
So your
made.
point is that, you're both joint tortfeasors, neither gets indemnity, and the provisions of the restatement of torts that may suggest otherwise don't apply in Maryland?
I'm not saying that they don't apply, but I'm suggesting that there needs to be a consideration of all the facts. In the case of the Max's case, I think that's why the Maryland Special Court of Appeals was so reluctant to even adopt a hard, fast rule when it came to implied indemnification claims. It's because there are so many different factual scenarios that arise in this context, and you can't just look at it from, the placement of the line in the chain of distribution.
Can I ask one more question? I'm sorry if but going back to the active, passive issue, I understand your position there, but if we were to look at this and agree with the district court that there's no genuine dispute of material fact about the level of active negligence, it sounds like you would agree in that scenario it'd be appropriate to require indemnity. You just think there's a genuine dispute of material fact?
I do.
Okay.
Either there's either there are facts in the record that are undisputed that show that Stratus was actively negligent, or if there are disputed facts that would support active negligence, it was inappropriate for the district court to grant summary judgment, and instead should have allowed the jury to decide whether Stratus was actively or passively negligent. I'd like to turn to the issue of attorney's fees. Should this court agree that Stratus is actively negligent, the argument on the attorney's fees is moot. But the district court did not err here, certainly did not abuse its discretion in denying Stratus's attorney's fees. There was no contract between Stratus and Jerry Care containing an indemnification
Counsel,
provision.
can I ask you, I don't really understand that argument. Having read Nova Research, it seems like that would cut in the other direction. Like if the contract actually said, here's an indemnity provision, but neglected to include fees, it seems like there you might have a pretty good argument that you don't shift fees. But when you're implying the whole thing, it seems like you would just be implying the baseline rule, which in Maryland appears to be that you do get fees under an indemnification theory.
I disagree that in the terms of the Maryland rule is that you would get attorney's fees in an implied indemnification theory. The two cases that were cited by Stratus in their brief, Jones as well as Nova, had to do with written agreements.
I know, but
that
that's not what
existed.
the reasoning turned on. But you think it is? You think those cases
I
are
do.
limited to a case where there is a contractual provision for indemnity that does not include fees?
Well, in the Jones case, the way I read Jones is that there was a contractual provision, but it used the word losses, and the court read into that losses could be considered attorney's fees as well. And similarly with the Nova case, it also included, it wasn't an implied indemnification case, but the court said with respect to the written agreement that you can read into that they implied that you would get the attorney's fees. It wasn't.
But I do see what you're saying. Factually, those cases had a contract in them, but under Maryland law, the whole theory behind implied indemnity, these special cases, is that is a quasi-contractual or a contract, an implied contract. But you're saying Maryland is going to have a different rule when it comes to a cause of action based on an implied contract and when the contract is written down. Because that just doesn't seem sensible.
I mean, if there's a written contract, you would look to the written contract.
Well, but
to
apparently
determine-
not. They will add in fees even if it doesn't provide for it.
If you can look to the written contract and decide, okay, when they said losses, does that mean that they meant attorney's fees? Or what was the intent of the party with respect to this written contract, and did it
But
cover
if it's just a
attorney's fees?
quasi-contract or an implied contract, you don't ask any of those questions.
No, you wouldn't, because there is no contract, and the law in Maryland.
But there's an
would be-
implied contract, so it doesn't.
There's an implied contract, but there's no provision for fees. And under the Max's case, which addressed whether Maryland would allow for attorney's fees in this context, held that it would not, or very doubtful that it would in the
Yeah,
context.
but that was before this Nova case, right?
It
When the
was-
Supreme Court, I thought, kind of straightened everything out.
The Nova case was 2 years after the Max's case. The Nova case didn't even address the Max's case at all. But I would argue because the Nova case involved an actual written agreement between the parties, it's factually distinct from what the Max's case was discussing. And in this case, because the district court correctly found that because the claimed damages for which Jerry Care was required to indemnify Stratus had to do with Carolink's damages, which didn't include attorney's fees, then Stratus could not recover those attorney's fees. Thank you very much.
Thank you.
May it please the court. Kelly Lippincott on behalf of Stratus Healthcare LLC. I want to look at what the undisputed facts are in this case. Counsel made reference to disputed facts, of which I'm not aware of any. The undisputed facts in this case is that Jerry Care held itself out as Eyewash's manufacturer. And there's, in terms of the active, passive negligence analysis, I'd like to go through what the various actions were of both Jerry Care and Stratus. First, as to Jerry Care, the first area of things that they did was in terms of labeling this product. This eyewash was manufactured and packaged by a South Korean manufacturer and by Caraway Products, Inc. There's a lot of detail in Jerry Care's corporate designee deposition that begins at Joint Appendix 436 that details how that relationship was formed. And their bottle that they have for their sterile eyewash is at JA 585. And an image of the box begins at Joint Appendix 592. And as you'll see from looking at both the label on the bottle and the packaging for that bottle, that was created pursuant to Jerry Care's contract with Caraway to manufacture the eyewash with Jerry Care's logo. Jerry Care became the exclusive seller of that eyewash. And the box that the eyewash came in and all the labeling on it was edited by Jerry Care. Jerry Care wanted Caraway to manufacture the product under Jerry Care's private label. They wanted Jerry Care wanted a sterile eyewash under private label as one of its own products to add to its product line. Jerry Care provided the logo and distribution statement, and that statement said it was distributed by Jerry Care and listed Jerry Care's address. Jerry Care's sterile eye wash provides on its label that it is distributed by Jerry Care Pharmaceutical. It makes no reference to any other company, entity, distributor, or manufacturer. And Jerry Care requested that Caraway make changes to the label, including edits to directions for use, changing the expiration date, and inserting comparisons to the national brand known as Bausch & Lomb. Jerry Care wanted its label to be consistent with the label of the national brand, and it was consistent in terms of the uses stated on the label and warnings listed. This was Jerry Care's demand and request for its product. Jerry Care likes to sell products with its label so that their name is on the market. And Jerry Care reviewed the contents of the label, both for the bottle of the eye wash and the box in which it was contained, prior to approving it for use. Jerry Care specified to Caraway that the eye wash should be sterile, and the label stated on Jerry Care's eye wash that it is sterile eye wash irrigating solution, and that it was distributed by Jerry Care Pharmaceuticals Corp. Jerry Care specified that the sterile eye wash was to be consistent in terms of purposes, uses, warnings, and ingredients. That was what it did in terms of the labeling of the product. Now let's look what it did in terms of FDA registration. Jerry Care's private label eye wash was registered with the FDA. Jerry Care identified itself as the labeler of the eye wash to the FDA when it registered it, pursuant to the Drug Listing Act of 1972. And it did not disclose to the public that Caraway or any other entity was the manufacturer of the eye wash. It did not want the public to have any other name in front of it except for Jerry Care.
So counsel, if I could interrupt you a little bit on the facts. I appreciate all the information you're talking about and how that led to the apparent manufacturer conclusion. I'm trying to make sense of a situation, when there is an apparent manufacturer who's not the manufacturer. I mean, factually, they didn't make it. I think that's clear too. So, is your argument that because they're the apparent manufacturer, they have all the duties that a manufacturer has? Or are you saying they just did a bunch of bad stuff that makes them actively negligent?
I would be amenable to both, Your Honor, but I'm.
What's the law?
What I am focusing on is the active versus passive analysis and how they are different. And I'm looking to see whether or not the actions of Jerry Care are significantly different from that of Stratus. And going through everything that they did in terms of the labeling, specifications as to the product itself, its directions to Caraway, shows that Jerry Care's actions were significantly different from that of Stratus.
Does it make sense for us to be looking at active and passive negligence when we have an indemnity claim based on strict liability? That just seems weird to me that, we got strict liability. In strict liability, the question is whether the product's unreasonably dangerous. You're not looking at duty, breach duty, and yet here we are kind of weighing negligence. Somehow that seems weird.
I understand what Your Honor is saying, but I don't see that the analysis for purposes of indemnification is necessarily, as you just characterized, a weighing of negligence. It's a weighing of the actions of the respective entities and what they did to determine whether or not their actions should be classified as active versus passive. They have both.
Doesn't that, I thought that the active-passive thing, like if you go up one level of generality, it's a question about culpability, and you weigh it based on active versus passive. But I guess if the inquiry is into culpability, why does that make sense in a strict liability case?
It makes sense in this case because the strict liability analysis was just based on the fact that this is a product that's used in human eyes. And so strict liability is the analysis that's applied to figure out whether or not we are liable to the plaintiff in this case. Now, the question as to whether or not two defendants have any obligation of indemnification to one another, that is where the active versus passive analysis comes into play, and differentiating the actions of the two entities.
Okay, what is passive negligence?
Passive negligence is what Stratus is.
Oh, no,
liable
I
for.
understand that's the position you're advocating. I'd like you to define passive negligence.
Defining passive negligence,
Is it necessarily defined with regard to the other tortfeasor? Or is passive negligence a concept that stands on its own?
I would say both. One, I think it is a concept that stands on its own.
Okay,
and
so what
Stratus
is, how do
certainly.
you define it then? If you're writing the opinion of the court, tell me how we should write what passive negligence is.
Passive negligence is not affirmative conduct, but it is secondary conduct to what should be the indemnitor in that analysis. So, I'm sorry, that's a horrible definition. Let me try to repair that.
But what has the passively negligent person, what do they do? In other words, in strict liability, you're not going to have a concept of duty, are you?
In passive negligence, the party does not take affirmative steps other than, like in the case of Stratus, pass the product through. They pass the product through, they pass the warning, the warranty from the Jerry Care bottle onto its packaging. It didn't have an
Right, so-
active role in the development, the creation, the marketing of the product.
Okay.
So Jerry Care, in terms of FDA registration, it did not disclose its identity, it didn't disclose the identity of any other entities. It used its own NDC number.
So counsel, if, it sounds like you know, the kind of maybe rabbit trail I went down with your colleague, that the restatement second allows an upstream distributor to go against a downstream distributor. Doesn't sound like allows, imagine no one here did anything other than just pass the contaminated eyewash on. Sounds like your position is that you would not be able to go against Jerry Care had they not done all the stuff you said.
Right, and there's another aspect of things that they did, and that was in terms of
Yeah,
testing of the product.
I'm not debating the amount of stuff, but just a pass-through distributor can't go downstream to another pass-through distributor under Maryland law. Is that your position?
Well, we've lost in source from this case. They were in between us and Jerry Care. So, yeah, certainly, I don't think that, I think Your Honor is correct,
So
that simply the location is not enough under Maryland law.
Okay.
But the actions of the respective parties is more than enough here.
Okay, but Stratus labeled the surgical packs as including sterile eyewash.
Yeah.
How does that factor in your analysis?
And you
Because
look at-
you're talking about just passing along in the stream of commerce, but they actually labeled this as sterile eyewash as part of its representation to the public.
We called the product what it's called, and it's called sterile eyewash, and that's how we listed it. That's how it is described and labeled and identified on Jerry Care's bottle and box that they created. We refer to it as sterile eyewash. It is sterile eyewash. It's supposed to be sterile eyewash.
Right, but the consumer looks at that and sees Stratus saying that this is sterile.
Right, and we were relying on the representation of Jerry Care.
But isn't that roughly the theory on which you are arguing for the sealed container defense? Like, we didn't do anything, we just passed it on. But I thought the district court found, and we affirmed, that no, the express warranty was like an additional thing you did. So how is that not
Right.
active?
Right, and
Not you, your client.
Right. Your Honor, I argued at that when we were here last before this panel on this matter, and I argued that, that was not an express warranty on our part.
Right, but
we were
given
just
that you were
passing along.
unsuccessful, I'm trying to figure
Right.
out why isn't the express warranty the active negligence here?
Express warranty is not active negligence when you look at it against the actions of Jerry
So
Care.
it's less, there's less active
Right,
negligence.
it's less active. It's not, well, I wouldn't say less active. It is passive. We are passing along a product. We are passing along a description of the product.
If I, can you let me ask a question? Thank you. And it goes back to Judge Keenan's question, I think. Is your answer that an express warranty is sort of per se standing alone, that is just passive? It's an express warranty, but it's passive? Or is it that by comparison to what the other tortfeasor did, it looks passive, relatively speaking? Because Judge Keenan asked you that question, I wasn't clear on your answer.
I would argue both. I would argue that
that's
it
why I
is
wasn't clear.
passive. And even if it is not considered passive, when you look at it against the other tortfeasor, who is more responsible here, whose actions would constitute active negligence when viewed as a whole versus passive negligence? And I think it's clear that the actions of Jerry Care were active negligence as opposed to passive or secondarily
How
negligent.
can that be? I mean, we're kind of in some, it seems, fictional world where we're talking about conduct with a negligence label without using traditional elements like duty and breach and all that. But express warranty means you affirmatively did something. Now, you may say it's less. I get your argument that they did more. But you affirmatively put a warranty on the box that relates to the eye wash. That doesn't sound passive. If it was passive, you might be liable to implied warranties. You just are a distributor. But once you've done something, haven't you done something active if you put an express warranty? That's necessarily active.
And in order to put that warranty there, what we did was rely on the warranty from Jerry Care. So what we
Right.
were doing was not making our own new warranty about the product. We were not actively issuing a new warranty. We were accepting the warranty set forth by Jerry Care as to its product and including it on our label of our product that then
Well,
had
they-
their product inside with the same
But
label.
what did they, and they did the same thing, right?
No, we didn't
And they
do-
did a bunch of other stuff about, holding themselves out and FDA, I got all that. But with respect to warranties and inspections or not inspections, I mean, they relied on someone downstream from them.
Well, they did do their own inspection of the
That
product,
post-
and they did their own testing
Whoa.
of the product as well.
That was after the problem came about, right?
There was Your Honor, they, after receiving the bottle, they inspected the label, they testified as to doing some periodic testing of product that they received. After they received a report of contamination, they accepted Caraway's report that there was nothing wrong with the product, but then
But
subsequent to that,
I'm sorry.
they
you're
did other
not-
testing. Sorry.
You're not suggesting, are you, that once there's a contamination problem, testing to try to see if there's something wrong with it in order to figure things out is testing, is the same as testing beforehand, are you? That seems like a subsequent remedial measure or something like that. I can't imagine it seems like you would have to talk about pre-distribution testing.
Factually, that's not exactly how it happened.
Okay.
So
Okay.
they had, on August 27, 2017, Jerry Care received a report of contamination from McKesson regarding a San Diego eye bank issue. They responded to McKesson the following month, stating that the manufacturer tested the product and concluded that it met specifications. That was the end of that. Then, for some reason, in October of 2017, Jerry Care had testing done by a third-party microconsult to make sure the integrity of the product was correct, that it was sterile, and to make sure they were selling quality product. But they testified at deposition that that was not in response to a report of any claim. They just were doing this as part of this, ensuring that the product was safe for their customers. And that discussion about that at Joint Appendix 458 to 459, and the report itself is at 598. Then, it's not until we don't have any further reports that we know of to Jerry Care until Stratus conveys a complaint to them a few weeks later.
Okay, Ms. Lippincott, just one question. Under the restatement, are you saying, restatement second, are you saying that Stratus is a supplier, or are you necessarily saying it's a retailer?
A supplier or a retailer?
Uh-huh. Are you drawing any distinction between the two with regard to the restatement second?
I'm sorry, I'm just going through trying to figure out what the distinction would be as between those two. I'm not sure that I can differentiate between those two, between
So you're saying the
Supply-
supplier is the same as a retailer, or is different? And I'm struggling with this, that's why I'm not suggesting it's an easy answer.
Yeah,
for you, but-
and I'm struggling with it as well, Your Honor.
Seems to me that if you're, perhaps, that if you're not a retailer, you lose.
Yeah, I think that we are more likely to be a retailer because we are providing it to the end user, the consumer of the product. Where we are in the chain, I would think that it would make us more of a retailer than a supplier.
Okay, but then
But-
that kind of ignores the fact that you said that this was sterile eye wash. So you're not just selling it, you're making a representation.
And most places where you buy products do make representations, where they place their products, how they describe it on the price tag below the item on the shelf.
Okay, thank you. And I took too much time, I apologize.
Thank you, Your Honor.
If Stratus had simply dropped Jerry Care's eye wash into its surgical packs, I wouldn't be here today. But Stratus did so much more than that. They've tried to characterize Stratus's role as being passively negligent because they just passed through this product. But this court has already recognized in the related appeal that Stratus did more than that.
Well, how do you define passive negligence?
It's just passing through the product. So moving the product from one entity to another.
Okay, do you have authority for that under Maryland law?
I don't.
Yeah,
But
okay.
that's the way I would see passive negligence.
But I don't understand what's negligent about that.
Yeah.
Where's the negligence?
Well, I mean, that's an excellent point. I mean, it would be negligent in the sense that you didn't do any testing of the product, any
Okay.
independent verification that the warranty that was made by someone else was in fact correct.
So like a failure to
A
detect.
failure to detect. So that's, if you want to talk about nonfeasance versus misfeasance, for example. So the way that the passive negligence has been described is a failure to detect within the chain of distribution. But here we have something very different with Stratus, and what they did, and they've described it as being less active, but under Maryland law, you don't look at degrees of fault. It's not, are you more responsible than I am? It's whether your actions were active, and you look at the nature of the relationship and the actions and the legal duty owed by each party. We would not want to have a public policy that would give Stratus a pass under situations like this, that they could say whatever they want to the public or make representations to CareLink regarding the sterility of the product that they themselves have repackaged and marketed and talked about their expertise in this field and said that this is a high-quality product.
Well, they're not getting a pass. I mean, they're responsible to the plaintiff. I mean, so it's not, I hear your argument, but they've already been held liable, and they got responsibility in that regard. Now, so the question is whether they come back and can get it against recover against the entity that supplied them the product that led to them being held liable.
And that's what I was
From a
talking.
policy standpoint, that's probably not the, I appreciate your argument. We could probably make policy arguments both ways on that.
But my concern is, it's not a pass in terms of its liability to CareLink, in this case, the plaintiff, but to say that, well, we're passively negligent. Just because Jerry Care, made a representation that it's sterile, we don't have to do anything else, even if we want to market this product ourselves to this field that we're an expert in and tell our customers and to the public that this is a sterile product without doing any testing, and then say, sorry, we're passively negligent. We don't have to be liable to, or we don't have to pay liable for the judgment. We can pass that on to someone else, or for our attorney's fees in defending the claims that were brought against us because of our negligence. And that's the pass that I'm talking about here, that the court wouldn't want to encourage. In this case, it is clear that Stratus took greater steps than someone like Henry Schein, who is clearly a passive party in this, that transformed it from a passive party to an active party. It could have tested that product if it wanted to. It didn't have to include its own insert in the product saying that it was sterile, and represented to CareLink that it was an expert in this field.
Do you have a position in response to Judge Keenan's question about whether Stratus was a supplier of the eye wash or not under the restatement of torts?
I think it's both it's supplier in the sense that it moves the product from one entity to another, but it's also taking greater steps in marketing this product by having its own label, by putting it into a surgical pack, by advertising and marketing itself as an expert in that field. It does much more than what traditional.
Well, the comment to the restatement says the supplier of a defective channel is required to identify a retailer regardless of whether his tort liability is based on negligence or strict liability, so long as the retailer has failed to discover the defect before selling the product.
Right.
So, A, does that apply to us at all? And B, where does Stratus fit into that if it does apply that rule?
Yeah, I don't think it applies here in the traditional sense where you would have someone supplying a product to like a big box store who puts it on their shelf and sells it. That's not what Stratus did. They weren't a retailer in that situation. They were a supplier in the sense that they supplied this product to CareLink, but then also took the eye wash and repackaged it into a separate product that it itself marketed and sold to CareLink under a different warranty. And under that situation, Stratus is actively negligent and would not be entitled to indemnification. Thank you.
Stratus did not repackage the eye wash. The eye wash was in a contained, closed, sealed bottle. That entire bottle was placed in our Strati pack, along with numerous other products from other suppliers and manufacturers. We took that package and put a label on it to describe to the customer what we were providing them. And there's a listing that lists both products that are sterile on the outside of them and products that are not sterile on the outside of them, because these are surgical packs that are used in the surgical field. And so when a Strati pack is opened, there's certain portions of it that are sterilized, and there's portions that are not sterilized on the outside. For instance, the Jerry Care bottle. And so when you see the Strati pack listing, there is a list of sterile items and non-sterile items. And then within the list of non-sterile items, we have listed the sterile eye wash, which is what Jerry Care gave us, what they call their product. There was, in terms of the idea that we had some obligation to inspect or to provide a testing of this product, there is no basis to say that we failed to detect because we had no duty to test it. We looked at the bottle, made sure that the seal was intact, but other than that, we didn't open up the bottles and test them. We had no obligation to do that, and there's no authority to say that we did, in the position where we sat, to open up those bottles and test them. Jerry Care, however, does do that as part of their normal practice of testing the products that they receive and sell under their own label. So the actions of Stratus were passive or secondary to the active negligence of Jerry Care. And Stratus should be granted indemnification against Jerry Care for its active negligence. And so, Your Honors, I ask that you affirm the decision of the district court as to the granting of indemnification against Jerry Care and overturn the decision in terms of the award of attorney's fees that Stratus incurred in defending the underlying action against Carolyn. Thank you.
All right, thank you. We'll come down and greet counsel and then go on to our next case. Where's my chair? Go ahead. Oh, please approach. We will hear argument next in number 241281, Randy Luna versus Tug Hill Operating. We will hear first from the appellant whenever you're ready.
Good morning. May it please the court, my name is Christian Ankoviak. I'm here with my co-counsel, Aaron McLaughlin, representing Tug Hill, the appellee. It wasn't all that long ago that Mr. Birch and I shared the privilege of arguing the Rogers case in front of you, Judge Harris, in a different panel, but before this court. I think the outcome of that case casts somewhat of a shadow over the arguments we intend to make here today. So for that reason, I just want to shine a light on two critical points and certainly take any questions that you all might have. The first of those points is this, and Judge Harris, you may recall this. The arbitration agreement that was at issue in Rogers that led to the decision in that case that's relied upon so heavily by the district court was a decidedly bilateral agreement. Many of those provisions which led to the conclusion in that case that the parties did not intend for Tug Hill, my client, to be an intended third-party beneficiary were because those provisions were squarely between what was then the contracting party, Rogers, and Rig Up, the staffing company. I think the agreement here is significantly different, aside from the fact that Griffin is the contracting party with the Texan, which is a single-member LLC by Randy Luna. If you look at the agreement itself, and it appears on page 31 of the joint appendix, you can go through that. There are numerous provisions significantly different from Rogers that explain, for example, the parties.
Counsel, can I just, sorry, so you're talking about the third-party beneficiary issue and why Rogers is different on that score?
Correct.
Okay, but I think the first thing the district court held was that Mr. Luna himself is not personally bound by this contract anyway. So even if you could enforce it as a third-party beneficiary, you couldn't enforce it against him. And your position in your brief is that there are no words in this contract indicating that Luna was signing on behalf of the Texan or in a representative capacity. But that's what the contract says, that they have entered this agreement to be executed, caused this agreement to be executed by their duly authorized representatives. So I found your brief sort of confusing on this point, and how is it not clear that Mr. Luna signed as a duly authorized representative, as the contract says?
I think there is no question that the agreement that was signed says just that.
Okay.
However, that is one piece.
So that's a change in position since you're, okay.
Well, there is a line in the agreement that says that the parties are signing
As representatives. That seems
as
kind of,
representatives. There's no question.
it's a big deal.
That is a big deal. But when you look at the agreement as a whole, which I think the district court was required to do but did not, it simply looked at that statement. It did not look at the agreement as a whole.
So let's assume there's a little bit of, argument that you could make that it looks in some of the covenants like it might pertain to an individual, but it's got a number of places where it's saying it's being signed on behalf of. What's legally wrong if the agreement says that with coming to that conclusion? Is the fact that if you kind of scour through the agreement and you see something that might be a little inconsistent with that you can, as a matter of law, look at those express provisions?
Well, as I look at the agreement, I think the agreement is ambiguous.
Wait, I'm sorry, if I were asked to sign this contract as an agent, your view is that even though, like, good news, I'm not personally liable, it says right above my signature, I'm executing this as a duly authorized representative, it would also be on me to go through the contract like, oh, hang on, it says he over there, not entity. So maybe actually I am personally liable. That seems like you're asking a lot of signatories to these agreements.
Well, I think, Your Honor, as I read the agreement as a whole, the agreement, to me, my interpretation, is that it was drafted for an individual to sign. I think the confusion when Randy Luna inserts the Texan into the contractor agreement is that it creates an ambiguous document that requires the court to look at it as a whole and to decide.
What is ambiguous about calling the contractor the Texan LLC and then saying that the company and contractor have caused this agreement to be executed, nobody else? And the contractor is defined in the contract, the first line of the first paragraph, as the Texan. So where's the ambiguity?
I think the ambiguity arises, Your Honor, because if you look at the provisions of the agreement, there are numerous provisions that would not apply to a corporate entity.
Doesn't that
For
just
example,
mean sometimes the contract is signed by an individual and sometimes by an entity, and they don't want, it's a form contract, they don't want to do a different one each time?
Well, I think that's potentially the case, but a better drafted document would clearly delineate those issues and indicate when somebody is signing on behalf of, for example, an entity but giving rights to that entity's
Don't you have a-
individuals under the FLSA or other provisions.
Don't you have a different argument? And, maybe it's not for us today, but it seems kind of odd that Mr. Luna could say, I'm going to operate as a LLC as it relates to Griffin, and then get paid by Griffin. He doesn't get paid by Tug Hill directly, and then bring the case as an individual. That's what seems odd to me. It looks like he wants the benefit tax or whatever of being an LLC, but he brings the case not as the Texan, but as himself individually. So that seems to me to be, I'm not even sure a LLC can bring one of these cases. Maybe, I've looked into that, it looks debatable. So it seems like there's a foundational issue maybe with the case, but that's not before us. The case is you wanting us to interpret the agreement a certain way. I think what Judge Harris and Judge Keenan say seem pretty persuasive. You could almost use that maybe in another argument, but it seems to me like we're kind of in the argument that's avoiding the heart of this whole agreement.
Well, I think the issue is, Your Honor, and you make a great point in that regard, but in order for me to enforce the arbitration provision against the individual who seemingly does want to take two bites at the apple, wants the protections of the LLC, but appears to have held himself out as an individual signing this agreement. We also have the alter ego argument, which we haven't touched on.
Well, you waived that, didn't you? By
I
not
don't-
raising it in timely fashion in the district court?
I don't believe we did, Your Honor. And
Okay, when did you raise it in the district court?
we raised it,
In your reply brief?
we argued generally that he was signing in his individual capacity in the principal brief. And when,
Right, but the words alter ego, when did you?
we did not
because
use the word,
that is a discrete concept in the law, you agree?
I understand. We did not use the words alter ego until the reply brief. However,
It's not just a distinct concept, it's a cause of action. It's what you do to get relief, and it requires evidence. I mean, alter ego, you are disregarding the corporate form. I think there's a good waiver or forfeiture argument, but it seems to me even bigger than that it's a claim that must be alleged in the complaint. And to my knowledge, you never alleged that. You just made an argument in the reply brief below.
well, there's no vehicle for us to allege alter ego. It was not our complaint. We were simply moving to dismiss. And so as we look at the agreement and made an attempt to compel arbitration, we argued in the first instance that this individual had an intent to be bound individually to the terms of this agreement. When that was objected to by the other side, we went deeper and explained the basis for that argument. We explained that we thought not only was he signing in his individual capacity, but that there was an argument to be made that he's an alter ego.
Yeah, but you didn't put in any evidence on that, and it's an intensely fact-specific inquiry. And if you didn't put in any evidence, I don't know why you're saying now we should remand for discovery. You didn't ask for discovery. You had to bring in some evidence, attach it, in this kind of a proceeding. The judge can go beyond the complaint and look at what the parties submit. And then if there's a disputed issue of fact, the judge has a trial, but you didn't ask for any of that.
Well, Your Honor, we thought that the evidence that the court should take judicial notice of was sufficient
What was
to
that?
raise that issue.
That he's the only member of the LLC?
That he disregarded the courted form. He hadn't.
That's not enough to-
I'm sorry. Well, what's your evidence that he disregarded corporate formalities?
It's in the joint appendix. It shows that the LLC had lapsed. He also, if you look at the registration, he used his home address. He was the single member of the LLC, by all accounts, taken with the fact that the agreement itself is replete with references that only an individual could exercise certain rights. It appears to us in totality that he was executing that on his own behalf.
I thought under isn't there stuff about whether someone is capitalized right, whether they have insurance? I thought that was even the standard you were citing. I mean, did you put in any evidence on capitalization or insurance?
We did not, Your Honor, and frankly, the assumption was that after looking at the briefing, the court would need to take evidence on that issue, if that was an issue the court needed to reach.
Yeah, but, I mean, I don't think that's how it works under the trial provision under this statute. I think that the parties have to kind of create an issue, something, I think we've said, like, you're basically applying the summary judgment standard. So there needs to be, you put in evidence, you show a disputed issue of fact, and then the judge has to have a trial.
Well,
But none of that happened here.
the issues and evidence that we pointed to, Your Honor, we thought was sufficient. It was concerning to us that the court didn't even take up that argument, and the court did not hold that we waived that argument. I think the distinction between waiver and forfeiture is an important one. Waiver is intentional relinquishment of a known right. Forfeiture, that court has the authority to take up that argument under D. Simone, which we cited in our brief.
Is the standard that we look at, as I understand your argument, it's that the district court should have considered alter ego. And is the standard by which we review that abuse of discretion?
I believe it's de novo. I think you have de novo review on that issue.
Okay, as a matter of law, why was the district court required to, I guess, like, have a trial on, or order discovery, although I really don't think that happens in these arbitration cases. I think, again, the parties just put the evidence out there. But as a matter of law, the district court erred in not having some kind of a fact-finding on your alter ego theory. Is that right?
I think that's correct, Your Honor. I think they didn't address it at all. They didn't even say that the information we did provide was sufficient.
My best guess is that the district court had no idea that you were asking for a trial on anything. I mean, you never said, here's the evidence, we have a disputed issue of fact now, have a trial. That's the way it's supposed to go under Section 4.
Well, I think the district court, in looking at what we presented, could have ruled in our favor. I don't think that it...
Based on the fact that he's the only member of the LLC, that's enough to show.
And that there were other indicia.
That's a different question. The other indicia you think the contract bears on the alter ego theory, that because of the way the contract is written, that's an art?
I think the fact that he's a single member LLC, that he used this home address, that he did not keep up the corporate.
Wait, I'm sorry, used his home address? Isn't that just like his contact information?
No, that was in the registration.
So a single member LLC has to go get a separate business location?
No, I don't think that's necessary. I think when you look at it in the totality, the fact that the LLC was formed shortly before the engagement with Griffin and Tug Hill, and after that appears to have been abandoned for all intents and purposes.
Is there any, I mean, yeah, we maybe spend a lot of time on this, but I'm just not aware of Maryland law, or quite frankly, any law I've ever heard of on piercing the corporate veil that would say the fact that you formed a LLC before you undertook a business enterprise somehow, suggests it's an alter ego. I would think that actually is what happens all the time when you're seeking liability protections and things like that. It seems like when you look at alter ego, you look at, is he observing formalities? Are there books? Are there minutes? Are there stuff like that? Do they have meetings? Is it capitalized? Is there insurance? Those are the things that, I think universally you look to at alter ego, and it seems like you're talking about things that are outside of the normal elements.
Well, I think those are certainly factors, Your Honor. I guess, and I recognize that my time is up, but our understanding was that if Judge Bailey wanted to explore that issue further, Judge Bailey is not shy. I would have expected him to ask us to present evidence on that issue to explore that further. But independent of that, we have argued that there are grounds to bind Mr. Luna in his individual capacity to this. We've raised that in various ways in our brief, and I understand my time's up, so I will cede the floor to Mr. Birch.
Thank you.
Good morning, and may it please the court. My name is Rex Birch, and I represent Randy Luna. Just as it did in Rogers, the folks at Tug Hill have no contract with Mr. Luna. They nonetheless want to force him to arbitrate with Tug Hill. So the folks at Tug Hill told Judge Bailey, Randy Luna has a contract with Griffin, and we, Tug Hill, are entitled to enforce that agreement. There's just two problems with that. Randy Luna doesn't have a contract with Griffin. Griffin has a contract with a company called the Texan LLC. Second, Tug Hill isn't entitled to enforce that agreement, and certainly isn't entitled to use it to force Mr. Luna to arbitrate with Tug Hill. On appeal, essentially, the folks at Tug Hill want to add another issue, alter ego. But Tug Hill waived that issue before the district court by failing to raise it until their reply brief. The district court refused to consider it, and in this circuit, a district court is entitled to refuse to consider an issue that is raised in a reply brief. That's Ridpath versus Board of Governors, 447 F3rd 292 at 305. Because the claim of alter ego was not properly raised in the district court, it is not properly before this court. This court should therefore affirm the denial of Tug Hill's motions. Let's start with Tug Hill's first problem. Why isn't Mr. Luna bound by the contract between the folks at Griffin and the Texan LLC? That's because, as Judge Keenan noted in talking to my friend, on page 1, paragraph 1, the contract defines who the parties are. Company is defined as Griffin. Contractor is defined as the Texan LLC. Under Texas law, which everybody agrees is the law that applies to this case, the court must apply these terms as they are defined in the contract. Moreover, both Tug Hill and Griffin conceded that the Texan LLC, not Mr. Luna, entered into the agreement with Griffin. Tug Hill told Judge Bailey, and I'm quoting, "The limited liability company that plaintiff created, the Texan LLC, is the contractor identified in the agreement," end quote. That's at page ID 51, note 1. Tug Hill also submitted a declaration from Griffin's executive vice president, where he admitted Mr. Luna signed on behalf of a limited liability company that he created, the Texan LLC. That's at Joint Appendix 29 at paragraph 7. So to the extent my friend is right and there is any ambiguity in this contract, and I do not agree that there is, but if there is any ambiguity in the contract, the only evidence in the record from both Tug Hill and Griffin is that this is an agreement between Griffin and the Texan LLC.
So, counsel,
Yes, sir.
I may be interested in, I'm interested in the arguments that are made. I'm also interested in sometimes in arguments that weren't. And I take your points on the issues you framed, but it does seem odd to me that you are the Texan as it relates to Griffin. You're the Texan when you get paid by Griffin, and you're suing Tug Hill individually. That's not, I grant you could certainly answer that's not before us. You'll deal with it at the right time. I also think there's some law that questions whether a LLC could bring this type of case to begin with, whether it even is permissible legally, the case against Tug Hill, that is. Do you have a problem, maybe that's not before us now, in operating with Griffin as a LLC and then bringing a case against Tug Hill as an individual?
No, because those are two different relationships, right? The Texan has a contract with Griffin.
Right.
Right. One of the people sent out by the Texan was Mr. Luna.
Well, no, was the Texan. Okay, that was sent out by the Texan was
Yes,
Mr.
the
Luna.
Texan sent out Mr. Luna, right? Then the folks at Tug Hill are alleged to have injured Mr. Luna as an individual. right? They're alleged to have denied him wages, proper wages, individually, in his capacity. The plaintiff down below is not the
Do you have
Texan
authority that supports your ability to do that?
LLC. Sure.
Okay, all right. We'll deal with maybe that at the right time. You think, okay.
Yes, absolutely. Because the beef in the lawsuit down below is between Mr. Luna as an individual and the folks at Tug Hill, right?
Well, that's the beef you claim exists. And my question is, do you get to, use your LLC, clothes when you like them and take them off when you don't like them?
Well, it's obviously a different issue, right? And I understand that we're doing that. So I will say this. There are cases, there's a 10th Circuit case, the name escapes me, I can tell you that's in the home health care or the janitorial industry, where the folks had individual LLCs directly with the person that they were working for, right? It would be the equivalent of, I have an LLC, I've contracted with Griffin, I nonetheless sue Griffin as an individual, Griffin, not Tug Hill, not some third party, right? But Tug Hill or Griffin directly. I sued them directly. And the court said, look, in the context of an FLSA claim, which is a federal right given to individuals, you can do that. You can have a LLC relationship directly with your alleged employer, and you can nonetheless bring a claim under the FLSA. And there are a number of cases where people have had relationships where they have personally denied that they are employees of a company. And nonetheless, the Supreme Court in the Alamo case said, because of the importance of this statute, we sometimes have to apply it even when people would affirmatively deny its benefits. Here, I think the situation is quite different because we have a contractual relationship between the Texan and Griffin. Texan sends out Mr. Luna. They could have sent out somebody, this is in the contract, they could have sent out somebody else. It could have been any one of their workers. If the folks at Tug Hill had shot him in the head, right, his estate would still have a claim against Tug Hill, right? It is functionally no different to me.
Okay, I appreciate your
Right.
answer. That's a lot, and I don't want to take up time from the issues before us anymore.
Right. And it's fair, like, it's something that, in the right case, maybe we'll have to talk about this again.
Well, maybe in this case, but.
Could be. So, I think for the reasons that I've already explained, that should be the end of it, but the folks at Tug Hill, if nothing else, they do not lack for daring do when it comes to trying to enforce somebody else's agreement. And according to Tug Hill, Mr. Luna expressly agreed to become a party in the contract in his individual capacity. Where is that express agreement? Well, to me, the best they can say is you'd have to infer it. For example, Tug Hill says the word by doesn't appear next to Mr. Luna's signature on the signature lines. However, right above his signature, the agreement states, company and contractor have caused this agreement to be duly executed by their duly authorized representatives. That's at Joint Appendix 45. Mr. Luna's signature also appears directly below the word contractor, which is defined as the Texan LLC. I'd like to just mention that Texas courts have long held that a signatory will not be held personally liable when the body of the contract indicates that the signature was in a representative capacity. It is the rule that where the body of the contract purports to be a contract of the corporation, the signature of an officer with or without an affix designating his representative capacity does not render it his personal contract. That's the Plan B case cited in my brief as well as my friends. Judge Quattlebaum, you brought up the restatement of agency earlier this morning. Texas,
Restatement of torts, but
you did, but yes, the restatements, I'm sorry.
that's all right.
Is my point. The Texas law, we recognize it as persuasive. We don't consider it binding, but it is nonetheless persuasive. And at restatement second of agency 157, they specifically address an instrument which shows agency in one part. And it says that if there is one part of the contract where it is clear that the agent is acting in a representative capacity, the fact that it is not equally clear in other parts is immaterial, and it is not necessary that he should constantly appear throughout the agreement to act only as a representative. Tug Hill nonetheless says the agreement is replete with references to he when referring to contractor. But let's go back again to page 1 of the agreement. The agreement itself says, when referring to contractor, that it could be he, her, or its. That's because this is a form contract, because they apparently did use it with both individuals and companies. But it tells us on page 1 that we're not going to play the pronoun game. If it's obvious you are referring to contractor, that's who we are referring to. As Tug Hill admitted to Judge Bailey, the Texan LLC is the contractor identified in the agreement. Tug Hill also
So,
argues.
Counsel, if I
Yes.
could, I take it your position that if you prevail on whether the agreement is an individual, is a agreement with the LLC over the individual, you don't need to get to the, and I guess on the alter ego issue, you don't need to get to the third-party beneficiary question? Is that
That's
the
correct.
case in terms
Yes.
of logic?
Absolutely, because they got to show both ends.
Right. If we get there to the third-party beneficiary agreement, it does seem that this agreement is not identical to the agreement in Rogers. There's references to clients. Tug Hill is a client. Why isn't that enough to be an intended third-party beneficiary?
So Texas law, I want to say you went to law school in South Carolina, but I'm guessing about that.
Is there something about the way I've asked questions that suggests that's where I went to law school?
No, but I know South Carolina, there's a Fourth Circuit case called Wackesser, I believe it's called, versus Knight Enterprises, where they talk about South Carolina law. It's a similar situation like this. The question's not what has to be arbitrated, but who must arbitrate. And in that case, they mentioned that South Carolina law also has, in order to be a third-party beneficiary, it has to be directly for the third party's benefit. Texas has similar language, but we're even stronger about it. It's not enough under our law that the third party could benefit even directly. The contract has to show on its face that it was intended directly for their benefit.
So,
meaning
short of language that says that, what can satisfy that standard other than express language that says we intend this to benefit the customers of Griffin?
The language that the Supreme Court, Texas Supreme Court used in Brumett was, it has to be clearly, fully, and unequivocally expressed that the parties intend to give Tug Hill the right to be able to sue on the contract.
How do you do it other than those exact words? Is there, can you, or do you, because I thought they also said you don't have to use those exact words.
We don't have a magic words test.
All right, so how do you do it without using the magic words?
Well, you say, hey, by the way, without saying you are a third-party beneficiary, you say, you are agreeing to arbitrate with the folks at Tug Hill, and Tug Hill can require you to do so. Right?
Can I ask you a
None of the
question?
legalese, none of, but.
So if Tug Hill is not a third-party beneficiary, I mean, there is a, I don't think you dispute this, the Texan at least, agreed in this contract to arbitrate any covered claims it might have against Tug Hill. If Tug Hill can't enforce that, is it a non-enforceable promise? Who could enforce that if not Tug Hill?
The folks at Griffin.
Why would they do that?
So I'm glad you asked that, because in the contract, they say if you have a beef, if Texan LLC has a beef with Tug Hill, we want you to sue us. That's in section 13.7.
Say that
And-
again. If Texan has a beef with,
With Tug Hill,
we want you to sue us,
we
Griffin.
want you to sue us for that problem, right? Not them. They also say in paragraph 20 of the complaint, if you have a beef with one of our employees, if you have a dispute with one of our employees, we want you to sue us, Griffin. We want the Texan LLC to sue Griffin, right? So to me, the reason that they have this in there is because they want to make sure that when they are having, if, you know, the Texan LLC wants to bring a claim against Tug Hill, that they bring it in arbitration. And so it's kind of the wraparound to me of the fact that whatever disputes there are between the folks at Griffin and Texan LLC.
But I'm
we're
just
going to do
looking
those
at
in arbitration.
20, and I haven't studied that point. But
Yep.
it looks like it's saying sue the contractor as opposed to its employees and directors and stuff like that. Is it saying the contractor in lieu of its customers?
My memory of that is that it says, if you want to, are you looking at 13F or 20?
I was looking at 20, I was trying to get back to 13F, so I'm
Gotcha.
not there yet. But
20
13
says, I'm sorry, sir,
No, I see what 13F is, I think, the first place you said, right?
it is.
And it does say, and not the customers, the company's customer or client. I see what
Correct.
you're saying.
Correct.
All right, I think that's probably more direct than 20, but maybe I'm wrong there, but.
Well, 20 has to do with, because also in the arbitration
Okay.
provision, right, it says the
All right,
employees.
go finish. Yeah, I want to hear your answer to Judge Harris's question. I'm sorry to interrupt you.
I'm sorry, Judge Harris, can I go back to your question?
Yes, I think so. I think my question was, why isn't this just an unenforceable promise? But your answer is Griffin could and would enforce it.
Yes, could, right? Imagine this, I could have a contract with my employees that says, look, if you go out to do work at Boeing and Boeing injures you in some fashion, I have the right to say to you, you need to go to arbitration with Boeing. I obviously can't bind Boeing, right? But I can bind my employee. I can say to my employee, I'm binding you, and if that happens, then I want to be able to force you to do that. That's a potential under this contract, I guess. The more direct thing under this contract to me is just, we've said we want you to bring any claims against these other people against us instead of them, and we want those claims to be in arbitration. And so we are sort of buttoning up all the angles here so that everybody understands that if the Texan and Griffin, or the Texan and whomever have a beef, that goes to arbitration. That's kind of my take on it. I want to go back to the third-party beneficiary issue for just a sec, or excuse me, the alter ego concept for just a second. Tug Hill knew that the contract was between Griffin and the Texan LLC. They say so in their opening brief to Judge Bailey. They say that the agreement is signed by, and that the contractor is the Texan LLC. They never raised the issue of alter ego until the reply. That's at page ID 117 through 119. Under the Ridgepath case from the Fourth Circuit, the judge is not required to address it. It is not an abuse of discretion under this circuit's law for the judge to refuse to consider it, and so there's nothing left to be done. I would also just say that the only evidence that does not show the company was inadequately capitalized, nor does it show he did not carry insurance. Unless there's anything further,
No, thank you.
thank you all very much.
On the third-party beneficiary issue, I understand that today Mr. Birch is arguing that magic words aren't required, but I think if you read their brief, that's effectively what they're saying. And I think if you look at the district court's decision at JA 71, the district court says, in this case, the agreement between the Texan and Griffin contains no provision stating specifically that it was entered into for the sole benefit of Tug Hill or directly for its benefit. To me, that sounds like magic words. And in this case, if you look at ConocoPhillips, which we cited in our brief, and numerous other instances, City of Houston.
Can I ask you a question about ConocoPhillips? Because that case seems so bad for you to me. It's talking about a whole line of cases in which the fact that the dispute resolution agreement includes non-signatory vendors or clients within its sweep does not, without more, demonstrate status as an intended third-party beneficiary. And then they go on to find third-party beneficiary status there, but not because they're within the scope of the arbitration agreement. So how is that line of cases not pretty bad for you?
Well, it also talks about the fact that there's an indemnification
Different kind
provision
of,
there.
but an indemnification, you think you have the same kind of indemnification provision as the one in ConocoPhillips? I thought they were really different. I thought in ConocoPhillips, I'm going to get this mixed up, but basically the Griffin was indemnifying Tug Hill, the Tug Hill equivalent for all of their litigation costs. So it made sense to have this arbitration agreement because it would benefit the indemnitor. I'm saying it wrong. I thought the indemnification provision was different, but if you think you have the exact same kind of indemnification provision, I'll look at it
I think the
again.
language is slightly different, obviously.
But I think it was meaningfully different.
Well, I think it only makes sense that the parties would give Tug Hill, the client, referenced in that Griffin agreement, the right to seek indemnification for
Okay.
a claim that would be brought in this
Okay,
case
so-
by,
So your position is not that the fact that this dispute resolution provision names clients as people against whom the other party has to arbitrate, that's not what you're resting on. You're resting on some indemnification provision somewhere in this contract?
I'm looking at the totality of those provisions and concluding.
Because it
that the-
seemed from your brief like your argument was as long as you were listed as someone against whom the other party has to arbitrate, you are a third-party beneficiary of that arbitration agreement, but that is not your position.
I think the position is looking at the totality of those
Okay,
circumstances.
what are the other circumstances here?
Well, the indemnification provision.
Which one?
being-
What does it say?
I believe it's page JA 34. Contractor agrees to defend, indemnify, and hold harmless company's clients, and it's their employees, and so on and so forth. So I think what you see in ConocoPhillips and City of Houston is a discussion that it's not magic words. It's more than an incidental benefit. It's a benefit that is direct, something that the parties in this case appear to have intended to benefit the clients, Tug Hill.
That's, I just, it looks to me like this, and I'm putting to one side the indemnification provision, but in your brief, you're arguing from the scope of the arbitration agreement. And the inclusion of clients, that's what describes, or that's what defines the scope of the arbitration agreement. But I think that is, and it does show that Tug Hill is likely to be a beneficiary of this agreement, but I always thought you needed more for third-party beneficiary status. Like, if I am going to paint my house and I tell the painter, also do the house of my friend Judge Quattlebaum, while you're at it, I will pay you double because you're doing two houses, and he messes up and doesn't finish Judge Quattlebaum's house, he can't sue, can he? Can he sue the painter? I mean, the painter's agreement is with me. He's a beneficiary, but he doesn't have a right to sue, does he?
I don't know if he has a right to sue.
But the fact that he was within the scope of the agreement I had with the painter, and that he is a beneficiary of that agreement by itself doesn't mean he can sue the painter. I mean, I'm acting like this is a real case, but it doesn't.
I appreciate your point. I think when we look at ConocoPhillips and the other cases that we cited, the case law appears to give the clients in those cases, the vendors, the clients, the subcontractors, the right to exercise something. In this case, it's the right to compel a party to arbitration. We think that we're a beneficiary of the commitment by Mr. Luna to send matters to arbitration. We think he interacted interchangeably with the entity and intended to sign that agreement knowing that he would go to arbitration. That's what we concluded. And I see that I've reached the balance of my time, so if there's any other questions, I thank you.
Thank you very much. We will come down and greet counsel.
I'm fine, whatever you want me to do.
We will greet counsel and then hear our final case of the day.
Good morning, Your Honors. May it please the Court. My name is Cadence Mertz, and I'm here with Patrick Bryant, the Federal Public Defender's Office, on behalf of Mr. Kruger. The search of Mr. Kruger's home and the seizure of his devices, which occurred in November of 2019, was based on stale and fleeting information and thus lacked probable cause under the Fourth Amendment. Approximately 3 years later, when the state case had been dismissed, federal law enforcement then unreasonably delayed in seeking a warrant to search those same devices that had been seized back in 2019.
Can I ask you a question about the unreasonable delay claim? So that is a claim that there's been an unduly long seizure because the police waited too long to get a warrant, your property was seized for longer than it otherwise would have been. And you were deprived of a possessory interest in the property. I just don't understand how that doctrine is implicated in this case where the property had already been seized by the state, and there's nothing in the record suggesting that the length of that seizure had anything to do with the federal warrant. Do you see what I'm saying?
Your Honor, I think I understand the question. The federal government, when it went to apply for the warrant, was relying on the seizure that had occurred 3 years prior. Those devices had been taken from Mr. Kruger back in 2019, but even if you fast forward to the point where the federal government says that it became involved in the case, which was 2022, those devices remained seized.
They did, but is there anything in the record suggesting that is because the federal government was in the process of getting a warrant and not because the state had seized them and nobody ever asked for it back? Because I couldn't find anything. I mean, maybe there's something floating around here that I'm not aware of, but I don't see any link between the federal government deciding to get a warrant and the length of the seizure.
I think the federal government is relying on the seizure by the state.
Right, but that seizure was timely.
Right. Well, that seizure was timely.
I mean, they didn't, there was no, the state seizure, you're not making an argument, or are you, that the state delayed in getting its warrant and that extended the, but The property was seized pursuant to a warrant, so there's no delay question as to the first, the only seizure of this property.
That's correct, Your Honor.
Okay.
We are not arguing that the state delayed. We are arguing that the state lacked probable cause.
Right, but that's a different- yeah.
Separate issue. I think that the issue with the delay is that at the time that the case was dismissed and the devices remained seized, at that point in time, the federal government had a duty to act quickly.
Why?
Law enforcement had a
Why?
duty to act
They
quickly.
didn't have the stuff, like, I don't understand why the state didn't just give it back when they dismissed the case, but apparently they didn't, and your client didn't ask for it back. How is this the federal government's fault?
It is our understanding, though the government would have to explain further, but the state's possession of the devices was then in furtherance of the federal government now picking up the case.
That's what I'm saying. So you think there's somewhere in this record that shows, but for the federal government picking up the case, the state would have returned that property?
I don't think that the government would say that. I think the government would say we were going to keep the state was going to keep these devices anyway.
Until someone asked for them back, and nobody did. It's not like your client went and said, now I'd like my stuff back.
But I don't think that that means that there's no possessory right that's implicated. I think that there was.
By what the federal government did.
Correct.
Okay.
Because the devices were still the subject of an ongoing investigation that had now been passed off to the federal government and involved.
So you think they were like constructively in the possession of the federal government at this point?
I don't know if I would say that, but I think there is.
I think you have to.
Your Honor, I think there's a very close relationship here. We're talking about the same officers. I'm sure the court is aware that this was all, the investigation was begun by one officer, and then even when it became a federal investigation, was still being undertaken by the same officer.
So,
So I-
but even accepting that, or wouldn't, if you did have that link, don't you still have to show, I'm still trying to figure out where the delay is. Because if the federal government taking over somehow implicates the fact that it has responsibility for the devices being seized, it acts on that within a couple of months. And so if this is a delay argument, what's the delay?
The delay is the period of time where the government is still holding on to the devices and has not acted to actually further its investigation and search the devices.
So are you saying whenever it is, and I tried to write it down so I couldn't. I mean, the federal government takes over responsibility, I'm just using those words loosely, in September of 22, right? I mean, July of 22.
At some point in 2022, no
Well,
later
it's not
than that.
at some point, it's like a couple months before the September 22 warrant, right? And so are you complaining about those 2 months?
2.5 months, yes, Your Honor.
So that's your unreasonable delay argument that you have here. I mean, first, we got to have the link. Second, you're saying that 2.5 months is an unreasonable delay?
We are saying that the 2.5 months is an unreasonable delay, and there is case law supporting that is an unreasonable delay. If law enforcement has a device and does not have a warrant that they've seized and they are holding on to, and then they take 2.5 months to go get legal authority to conduct the search, that is unreasonable. They have a duty to act diligently.
When they have, but I mean, I guess I'm going back to the first part. They don't have those devices.
Your Honor, and so the 2.5 months is the basis of our argument, but that's the minimum delay that was present in this case. Actually, the delay can be taken back. You could look at it as going back to November 2019.
The
at which
federal
point-
government was supposed to get a warrant right then, you would say.
I would not say that they had to get a warrant right then, but the federal government had there was no impediment to the federal government coming in and conducting an investigation. The government has said, the federal government was sort of ceding authority because the state was investigating. But first, the federal government often will investigate at the same time as the state government. Second, the officer is the same. He becomes a task force officer. We do not know when, but he is the same officer. And third, the federal government then relies on that seizure, and that seizure occurred in November of 2019.
I feel like there's actually a third step to your argument, and the state isn't raising this, but I would be interested in any thoughts you have. It's not clear to me why, even if there was a delay, an unreasonable delay here that implicated a possessory interest, that exclusion of the evidence would be the remedy. And in, the Hudson versus Michigan, the knock and announce case, the court says, look, exclusion is about privacy interests. And when the violation has to do with something other than privacy interests, exclusion's not the right remedy. And so I'm just wondering why exclusion would be the remedy for an infringement on a possessory interest here.
Your Honor, there are, first of all, the delay it is an obligation of law enforcement to act with diligence.
Right, but so maybe he can, okay. No, go on, I do want to hear too, yes.
Thank you, Your Honor. It is to then have the responsibility to conduct the investigation, to seize the item, and then wait to obtain a warrant for 2.5 months or for 3 years, whichever number the court relies on. That is a violation of the constitutional duty of reasonableness under
Okay,
the Fourth Amendment.
Ms. Mertz, I'm a little confused because when I read the JA, the argument that you were making to Judge Brinkema, weren't you relying on the 11-month period at JA 83? You're talking about the 11-month delay?
Judge Keenan, there are two separate time period issues in this case, and the 11-month, I think it's actually probably closer to 10 months. That period of time is part of our staleness argument, which goes to probable cause. The delay issue is a separate and independent basis why this warrant was improper, but it is a separate period of time.
So are you saying that when the judge was ruling on JA 84, talking about the complexity of going through and doing the forensic searches of these types of devices, I'm not finding that the length of time is so problematic that it would justify suppressing the evidence? What was the judge referring to there?
Your Honor, I think that reference is specific to the staleness argument, which was, at what we've argued in terms of probable cause is that not only was this a very brief and fleeting interaction that law enforcement identified in January of 2019, they then waited another 10 months before going and getting a warrant to conduct the search.
And that's not at all, I guess I'm confused here. That's not at all part of your argument today?
It is part of our argument. It goes to probable cause. And we've argued that the delay is a separate reason for why the warrant will be invalid.
Okay.
And
Okay.
the
Because
delay.
it seems to me that the real delay and the issue of staleness is that period,
Agreed.
rather than simply, the bureaucratic machinations of, transferring the devices from state to federal custody and all of that.
That's
Seems to
correct,
me
Your
the
Honor.
real rub is that 11 months, isn't it?
We absolutely agree with that, and that is the primary, so that there are two arguments. First is that there was a lack of probable cause, and that goes to the staleness issue that Your Honor is raising.
Do you claim on staleness? I think that is a legal issue we review de novo.
Your Honor, I think it's a combined issue of fact and law, Your
Most of the
Honor.
time, a motion to suppress is not that way. It's something that we review for clear error, construe the evidence in the light most favorable to government. Are we supposed to do that?
Well, Your Honor, Judge Brinkman didn't really delve into the staleness question. I think, as Judge Keenan was just quoting, it was a very brief part of the argument at the end. Now, we had raised it in our papers and spent some time on it in our papers, but I don't believe that there was much of a factual finding other than that probable cause was not an issue.
Well, I'm still, maybe, so if your argument is she the district court committed a legal error, you can say that, and we might do that, but I don't, if you could just answer how we are what's our standard of review for the staleness argument?
Your Honor, I think the court can look de novo at the legal conclusion, but with respect to the facts, I think the court has to consider what Judge Brinkma said about the facts, but there was no real finding made. It was, what she said was that she didn't find staleness, but she also spent very little time on it. It was really about whether or not the affirmation had been signed. There was the factual issue that was raised at the hearing specifically, had to do with whether or not how the second page of the original application was lost and whether or not the affirmation had been signed.
How was, no, I'm sorry. No. How was this a search? In other words, why was a separate warrant required
Your
in
Honor,
this case? The property was already out of the possession of the defendant pursuant to action by state authorities. So the fact that the federal government then viewed the copy of what was seized, how does that become a search? It's a little atypical, you agree?
it is. I think it is a little atypical, and we haven't found a lot of cases with a similar factual pattern. But I do think it is a factual pattern that comes up a fair amount, at least at the district court level, because it is not uncommon for the federal government to take a case over from the state. We get a lot of cases in that manner. It is a search because, as we've argued, we don't believe that there was probable cause for this seizure and for the search, and therefore the federal government needed to go get a valid warrant to conduct the search.
Does the defendant have a possessory interest in the copy that allegedly was searched?
Your Honor, the defendant certainly has a possessory interest in the devices, and there are just 2 points I want to make about the possessory interest in those devices. First, I think the government is arguing, well, there was contraband. I see my time is up. May I finish answering the question? The government has argued that there was contraband on the devices, and therefore there was no possessory interest. But that is a conclusion they can come to only if they have a valid basis on which to be searching the devices in the first place. It also doesn't address the possessory interest in all of the other content that is on the devices, and the courts have recognized that computers and cell phones in this day and age have so much information on them that there continues to be a possessory interest. Thank you.
Good morning, Your Honor. Rachel Rothberg for the United States. I just wanted to quickly clarify the findings that the district court did in fact make during the evidentiary hearing. First, the district court did make factual findings regarding staleness. In Joint Appendix 86, the judge said 11 months is a very short period of time, looking to the nature of the contraband being searched for. The judge also referred to the case law, saying that the length of time here is not such that it per se means it's a stale search. Joint Appendix 85, Joint Appendix 86, the judge says, as the government correctly points out, and based on the court's experience with child pornography cases, offenders often collect and keep the materials. With respect to the unreasonable delay on page, that issue, the district court did make findings as well on the unreasonable delay issue. I would note that in the district court, the defendant was arguing about the 3-year period, not the 2.5-month period. And so the court on JA 84 to 85 was the court said, I'm not finding in this case that the length of time in any respect is problematic, that it would justify suppressing the evidence. And then the court went on to talk about the COVID-19 pandemic, which occurred between 2019 and 2022. The court talked about the complexity of these forensic searches, and then, of course, the fact that the defendant never made any requests for the property
Well, the
until.
court seemed to kind of blend its analysis, didn't it? I mean, kind of addressing the probable cause as far as staleness, but then going into the complexities in this type of evidence, maybe arguably addressing staleness, but then talking about COVID-19, the court was talking about delay in the federal pursuit of the case, was it not? So it seemed, it's a little confusing, I guess, or maybe just to me, but a little confusing with regard to the analysis
Yes,
of when the court was talking about probable cause and when the court was talking about the federal execution.
Yes, Your Honor. I do believe there is some distinction made, though, that the district court is talking about the 11 months and the probable cause being found based on the Magistrate Harris's testimony. And then the court separately goes on to the unreasonable delay issue because the defendant on JA 83 to 84 at the very bottom, that's when the defendant is pressing the delay between 2019 and 2022. And so the court, as I understand it, is responding to that period of delay.
Okay.
Can I ask you a question about the unreasonable delay claim?
Yes, Your Honor.
I didn't understand your argument that you didn't need to get a second warrant. You could have searched it without the warrant. I mean, I understand why you think you didn't need to get a warrant, but I don't see how that helps on the delay claim. And if anything, it seems to kind of make it worse. Like in your average case, if, the police, someone take my phone at an airport, and then they hang on to it for 2 weeks, like now they've created a 2-week seizure and I've lost an important possessory interest. I don't see how it gets better if they say, surprise, we didn't even need a warrant. We just were putzing around, but it turns out we could have searched it under exigent circumstances. Doesn't that make it worse?
Your Honor, I believe the issue here is, it's our position that this evidence was lawfully retained by Virginia State Police throughout the entire time period. It was the residents.
Yeah, I understand that. I was just wondering why, in connection with the unreasonable delay claim, you were making an argument that we didn't need to get the warrant anyway.
I believe, we believe that we did not need a warrant and the seizure, there was no.
And that makes it better. Had there in fact been a seizure, it's better that you didn't need the warrant. It took you 2.5 months to get it. You didn't even need it. You didn't have your stuff for 2.5 months, and it's better that we didn't need it. That just seems backwards to me. It's a minor point. Feel free to go on.
Yes, I believe we were not considering, because in our view, and what is shown in the record and is not disputed, Virginia statutory authority and Virginia State Police had, based on their retention policies and their forfeiture proceedings, they could have disposed of the evidence at any time, and because it contained contraband, which they, it contained contraband, and that was discovered based on the lawful search and seizure in November of 2019. And so in our view, searching a copy of the extractions was not another seizure, and that would not implicate the Fourth Amendment rights of the defendant here. If this court disagrees, I would also just note that good faith would be applicable here to both the purportedly defective state search warrant with respect to probable cause, as well as the unreasonable delay claim here. The defendant in briefing says that no court has held that good faith would apply to this type of constitutional violation, and I would just note that in the Smith case.
Tell me, help me understand, walk through not just good faith broadly, but what are you saying was done in good faith? What was the decision that you say was made in good faith?
There are multiple steps of good faith here, Your Honor,
Right.
in our view. There is good faith for the execution of the state search warrant. The missing page was an intact state search warrant when it was executed. The missing page was only determined later on.
Do you think the good faith analysis goes to the state court or to the state law enforcement officials or to the federal ones?
It could go to both, Your Honor. And the defendant is not even challenging that good faith wouldn't apply for the state search warrant. It's only, the argument is only made that good faith would not apply to the purportedly unreasonable delay for getting the
Okay, but
federal
the whole
warrant.
concept underlying good faith is reliance, reasonable reliance. Don't you agree?
Yes, Your Honor.
Okay, so what was the federal government relying on that would put it within the ambit of the good faith exception?
The reliance is on the warrant that that Magistrate Harris signed off on, found probable cause.
So they were relying on the probable cause determination of the magistrate.
Yes, as well as the probable cause determination of the federal magistrate.
But that's why I'm trying to have trouble. I mean, if they testified or believed they had, that the state court's warrant, gave them a reason to rely, they could rely on that and search the copies. I just didn't get the impression that's what they were doing. And then as for the delay, the warrant came after the delay. So the argument would be that they relied on something to delay. And I think you got, I think that the defendant has some real challenges on the merits of both arguments, but it just doesn't, I'm not following the good faith. It seems like you're more saying, okay, looking at this case as a whole, they were acting in good faith, but I don't think that's how it works. We look at specific actions and what they're relying on, and I'm just trying to see how that matches up. I mean, good faith is not like, harmless error, some, roving thing that makes something wrong, all of a sudden right. You gotta rely on something, and I'm not seeing it here.
Yes, I believe what we'd be arguing is that this law enforcement officer was operating in objectively reasonable reliance on the state search warrant, which 3 courts found had probable cause, and that determination deserves substantial deference. So that is one piece. He had no reason to believe that he was violating the defendant's constitutional rights. Accordingly, the officer, because this case law, there is no on-point relevant precedent here, the officer had no reason to believe that the basic retention of these devices and the extractions thereof were implicating the defendant's constitutional rights.
Okay, if I could follow up, and I'm sorry, were you finished there?
Oh, no, go ahead, Your Honor.
Okay, I'm having trouble, I guess, like Judge Quattlebaum, or maybe separately from him, with the concept of good faith being applied here, because there was a federal warrant obtained, and an independent assessment was made. An affidavit was submitted in support of the warrant, and the federal warrant was issued. So how can you then go behind the federal warrant and rely in good faith on the actions that were predicated in granting the state warrant?
Our argument, Your Honor, would be that because there was full disclosure to the federal magistrate, one of the purposes of Leon is to deter law enforcement's culpable, reckless, deliberate misconduct of constitutional rights. And here, the officer, a reasonably well-trained officer, would not have any reason to believe that the state search warrant itself.
Right, but there was nothing to rely on, it seems to me. I'm just being the advocate here, but it seems to me that there was nothing for the federal government to rely on, because its magistrate made an independent assessment based on the affidavit submitted under oath. So it's not as if you had a defective federal warrant. So how can you articulate a good faith exception with regard to the state's action when there was a completed federal process that occurred here?
Well, Your
Either
Honor,
the federal magistrate was correct or incorrect on relying on these facts in support of the warrant.
That's correct, Your Honor, and that's why we believe this court would not need to reach the good faith argument, because the federal government got an independent determination of probable cause by the federal magistrate, and again, the district court found that there was no error here, and no constitutional error. And so we believe that this court does not need to reach the good faith argument if there's valid probable cause for the state search warrant, which we believe there was. And unless the court has any further questions, we would ask you to affirm.
Thank you.
Thank you.
Your Honors, I wanted to go back to the issue of probable cause. This is not a case where the probable cause was, that was presented both to the state magistrate and to the federal magistrate was essentially identical, except that once it was presented to the federal magistrate, it was many years later. But in this case, this is not a case where there was evidence to support the inclusion in the warrant application of collector of CP language, the inference that which is what the government has relied on to say that the 11 months or 10 months that passed between January of 2019 when this conduct was observed and November of 2019 when the warrant was applied for, to say that that passage of time was not relevant. But in this case, it is not a case like some of the others the government has relied on where there were additional indicia that the person who was the subject of this investigation was a collector. There was...
Counsel, can I ask you just a question about the collector thing? The affidavit in this case also says a lot about a different rationale that we have sometimes relied on to find long periods not adding up to staleness, which is however long it's been, we can always get this stuff off your computers. Like, we have these special ways that we can find information, even if it's been deleted, even if it's been cleansed. So it really doesn't matter how long it's been. And there is that showing in the affidavit. So why isn't that enough here?
Your Honor, the reason it's not enough is that in order to sort of reflexively rely on that justification, there has to be some indicia that the computer you're targeting would have had this information on it and had it on it for a period of time.
How come it has to be over a period of time?
Because otherwise, then the government is relying solely on a one-click. The one-click that the court has said is that's not enough for probable cause, and particularly not here, where the information that was observed in January 2019 was via a Wi-Fi hotspot, doesn't even necessarily point to a person present in the home. This is not a landline where it's hardwired in there.
But this isn't I'm sorry, I guess I meant, why isn't 4 days enough? Wasn't there activity observed for about 4 days?
Right, but this was uploading via peer-to-peer BitTorrent network, and as the government has pointed to the BitTorrent network as essentially the way that network functions is a person who requests files over BitTorrent, once those files start downloading on their computer, then they start to send them back out to the world. The person may or may not even have seen the files yet. So the government hasn't pointed to anything in the evidence that this person had actually sought out CP, or that they clicked on a link that was titled CP or that contained, obviously contained child pornography.
So your position is, so this isn't really, that's not really a staleness argument. Isn't that just like there was no probable, even if they had done this the next day, there was no probable cause?
Your Honor, that's correct, but
Okay.
that will be part of it. But then you add in the amount of time that has passed.
But
you take the
that's-
fleeting nature and the amount of time, and those things compound to sort of thin out the evidence the government was pointing to.
I don't understand why it seems like there are two questions. Is the 4 days of observed activity enough to get a warrant? And then, even if it was, did they wait too long? I don't see why the part about, yes, the collector stuff is in the affidavit, but so is whatever was on there we'll still be able to get it years later. I don't see why that doesn't take care of the staleness problem as distinct from, well, was there ever enough for probable cause here? I'm not sure which argument you're making.
Your Honor, I think we're making a both. But I think to address the specific issue of whether or not there was enough evidence to say this information would still be found on the computer, I don't believe that the government had put, or that the affidavit supported that. They had, the language that was included was boilerplate language and was not pointing to any, excuse me, Your Honor, was not pointing to any specific file that would be found or was known to have been found or have been downloaded, because what they were describing was uploading from via a device that was connected remotely. Unless, what the government is really asking for here is a per se rule that, once child pornography is involved in a case, that any amount of time, the government can wait any amount of time, and we don't believe that the Fourth Amendment supports that. Thank you.
All right, we will come down and greet counsel, and I'll ask the deputy to adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.